our last case for the day. It is Frase v. Frase, if I'm saying the name right. Each party will have 15 minutes to present their argument. The panel may reserve up to 5 minutes for about how long would you like to reserve?
I think I'd like 5 minutes, please.
All right, very good. The court will make it 5 minutes. I'll try to let you know when you're down about a minute left in your time.
Thank you.
Arguments are being recorded. When you present your argument, please introduce yourself. Stay behind the podium if you will. Keep your voice up so we can hear you. That again is being recorded. You should not use the name of children, minors, or victims. I don't know that applies to this particular case, but just if it were, please don't use the name of those folks. The judges have read your briefs and are ready to proceed whenever you are.
Thank you, Your Honor. May it please the court. My name is Leslie Grasky, and I'm here on behalf of the appellant Keith Frase. We're here because the Ohio Supreme Court has told us exactly what to do in a case like this. Spousal support should have a definite duration so that the parties' relationships are known and they can be terminated within a reasonable period. It's Kunkel versus Kunkel, seminal spousal support law. An indefinite term can be appropriate, but that is when there is a marriage of long duration. Our marriage lasted 22 years as of the time they separated, but then husband paid support almost a full year before there was a temporary order. So he has, I would say, some credit for time served there already. Then he pays under a temporary order for another year. And the court...
Would you agree this doesn't even give an indefinite term? It just retains jurisdiction?
Right, there is no term.
So even though the statute says the court's to determine the duration, there actually is no term on this order?
Exactly right, Your Honor. There is no termination date. And
you're not saying we should overturn every decision from a domiciliation court where they set a term of support whether it's a 40, 35-year marriage without a specific duration?
Because the rule that was enunciated by Kunkel and has been followed by courts all over the state is that a marriage of long duration, parties of advanced age, definitely not here, they're 48 and 51, and a homemaker spouse with little opportunity to develop meaningful job skills. That's not the case here. She has been a nurse. She's made more money in the last 2 years than she had previously. She claims to have anxiety and depression, but that's when she starts making more money, is when she's diagnosed with her anxiety and depression and is finally treating it.
Would you say this is a question entrusted to trial court discretion, reviewing the factors of 310518 as to what the duration of support should be?
I'm sorry, I missed
Is it a question of an abuse of discretion in this case?
It is.
Looking at the factors.
Yes, because there's no finding of that. There's nothing to justify a spousal support award that has no termination date, no duration whatsoever. It's not even until further order of the court. It's just hanging out there over his head forever. And if one thinks about it, unless he has a stroke or a car accident or some income reducing accident, he's never going to get relief because duration of time alone isn't going to be a change of circumstances under the statute. You need to find something that's substantial.
Counsel, I just want to make sure that we're all on the same page. You're not arguing that this isn't a final appealable order because there's no, the court hasn't given a specific date or said specifically that's indefinite duration.
I am not. This is a final and appealable order because it orders spousal support and it actually discusses that it can be modified upon a change in circumstances. So I think the implication is there. I think it's improper, but I think the implication is there that it is an indefinite term.
Lifetime support until something happens.
Yeah.
Unless something happens.
Essentially.
And I was a little confused when I was reviewing the record too, because it seems like there's contradictory things at what has been said as to what constitutes a change in circumstances, or what, or when this would, this support would terminate. In other words, I think at one point it says upon remarriage,
Yeah,
death.
which would be
But,
termination. Yeah.
right, but at the same rate, I'm not sure that's completely included in everything. In other words, the final order, I'm not sure says that, does it?
I think it could be hanging out after his death. not listed as a termination date. I think it's clearly an abuse of the trial court's discretion. Particularly, there's no finding that would justify this kind of onerous implication. You know, the court has looked at semi-long-term marriages, 20-ish year marriages, but when the payee spouse has the ability to work and to self-sustain, it's not an indefinite award of spousal support. And in this case, husband made 128.7, absolutely stipulated. Wife made 57, but she has another 10 grand in bonuses, which weren't even included in the calculation, which was done by the agreement of the parties. But that's pretty substantial ability to earn a living and have a meaningful employment in the future.
Was the bonuses divided in tier 2 support? I vaguely remember the separation agreement including tier 1 and tier 2. Were her bonuses tier 2 support?
I don't believe hers were, I'm not positive, I can tell you that.
Do you recall anything being the tier 2 support if it wasn't her bonuses?
Not from her. His bonuses are tier 2.
Okay.
And we weren't arguing with doing something fair between the parties, but wife wanted 1 year of support for every 2 years of marriage, which is pretty substantial when she is capable of earning 60 plus. And he wanted 1 year for every 3 years. He asked for credit for the time he had served. The second he moved out, he didn't stop supporting. He was still paying all the household expenses. And when the temporary order came on, he continued to pay that. So he has put a substantial effort into providing support for his wife. He should not be looking at forever support from here on out, particularly in light of the fact that the trial court made no findings that would justify an award of spousal support forever. I know you're going to hear that there is evidence in the record upon which findings might have been made, but they weren't made. And I don't
It's
think...
similar to a best interest decision where the trial court at least has to acknowledge the factor exists and say, I've reviewed the factors?
Something, you know, preferably saying I relied on this and this and this, but I don't feel that if you look at the statutory factors in the case law from Kunkel and its genesis, there is any justification for spousal support that cannot be terminated. We know that if you go in and you don't have a substantial change in circumstances, nothing is going to happen. It's going to be forever. If he finally retires, maybe they'll...
How can we rule that the court abuses discretion when there is no ruling? There's no ruling. The only ruling the court was supposed to make was duration, and the court didn't make a ruling at all. Wouldn't this be a final appealable order issue? That we could send this back and get a final appealable order?
Well, the court did make a ruling as to duration, in essence, by saying...
It just retained jurisdiction. That's different than making a ruling on the duration, right?
I can hear your point. I think that is error rather than lack of finality, because this court, I mean, if husband had not been dissatisfied with this, everyone would have had enough information to go forward and enforce this order. But if it's not a final order, then we can go back and see whether we could get the court to consider some factors in this, including the ones represented by the Ohio Supreme Court, that parties who are capable of supporting themselves and are not of advanced age don't need support forever. I mean, the wife even testified that, you know, she could obtain better employment, she could get more training, but she just didn't feel like she was going to do that. So the husband may go and have increased income every year, which will be shared with his wife through tier 2 support, if nothing else. But she's just going to stay where she is. And if he pays until his retirement, when almost certainly that would be a substantial change in circumstances, he'll have paid more support after the termination of the marriage than before. That's not the kind of result that was intended by the Ohio Supreme Court in Kunkel. There's a couple of awards where...
Counsel, you're down to about a minute of time left, just so you know. 1 minute left.
Okay. I believe this is not the kind of situation where you've got a 75-year-old wife and She had limited working skills, and she's given 5 years of support out of a 12-year marriage. It's not appropriate that that the trial court granted lifetime support. Thank you.
Thank you.
Attorney Ray Jones on behalf of the appellant. Kent versus Kent, 2012, Ohio, 2745, 9th District Court of Appeals, head note 5. A marriage of long duration will permit a trial court to award spousal support of indefinite duration without abusing its discretion or violating the principles of couple versus couple.
But there isn't an award of indefinite,
No, it's not an indefinite award. It is a award subject to continuing jurisdiction.
right?
That's the bottom line. I mean, they're trying, but I guess kind of an indefinite award, I've always said sometimes to the clients, it's like death do us part, a whole new meaning. But again, the statutory, it's clear, number one, there is termination upon death again. And again, it is simply a court exercising jurisdiction, to retain jurisdiction, depending upon the changes of circumstances that would exist or could exist. We have not young people. This isn't like these are 18-year-olds who got married and then they got divorced at 38. These are people who are, rolling up into 50s and so on. They're going to be going into 60s. Again, these are times of jeopardy that we live in today's world with reference to our economy and what's going on. It is only appropriate that, and again, kudos to the court for retaining jurisdiction in this particular case, but it is not a lifetime award. It is a court that recognized, about findings of fact. Sorry. There was no request for findings of fact by the other side, and now at this late date to go, we don't have any findings of fact. Every one of the criteria, which whoever has read the transcript, every one of the criteria which exists in Title 31 concerning spousal support that applied in this case were addressed and testimony was elicited. So the court had more than enough in the way of foundation. And this was a magistrate's decision that came out that was, of course, signed off. That was signed off, not of course, sometimes they aren't. Signed off by the judge. And there's X number of days.
And I want to make sure about that, as a matter of fact. But have you answered Judge Lanziger's question? Okay. All right. Because that's how I was getting confused at first, because I was remembering some things. So the magistrate's decision we have, and it's labeled judgment to decree of divorce without children, but the matter came on for final hearing before a magistrate. Okay, so do you consider this then to be a magistrate's decision?
Yes.
Okay, so
That is adopted by the court.
you had 14 days to object.
And she did.
All right, so I want to make sure about that.
Not she, I'm sorry, appellant.
Okay, that's fine. But I guess my point is too, I was a little confused because it seems like this is very different for me in reviewing divorce cases because there's so much interlineation between, here's, like it says, magistrate so-and-so, 8-1, da-da-da, and then magistrate so-and-so, and I'm not sure why all that stuff is in there, written handwriting. And then on the settlement agreement itself, there seems to be different terms than what's in the actual order as well. So I'm just a little concerned about the procedure. I'm having trouble with it.
Well, procedurally, there certainly would be an ease of this court kicking it back and saying there's no final appeal order that's mentioned in my reply brief. There are a couple of things that fell through the cracks here on this one. We've got the objections filed on the last day. Then the local rules of Summit County require that you have to, within X number of days, well, first of all, within X number of days after the issues of the decision, which again, that timeline is still court held, you have to then request the status of findings in fact from the magistrate in the case. You have X number of days to do that. That was not done. You also have X number of days that you are in fact supposed to get things off to the court reporter, instructions to the court reporter, payments to the court reporter. Those were not done. And in John's viewpoint, I look at this appeal as just a way to get the transcript up and get it back in front of the judge for objections.
I was just going to say, where's the notice on this that you're entitled to file objections?
Again, I had to run.
It talks
I
about
had to
being
leave my
a
appellate
decree of
file
divorce,
because I was taking care of something else.
Well, my point is, and my concern is, it talks about being a decree of divorce and not a magistrate's decision that's subject to objections.
That is
And there's
correct.
no notice on it that I see, and maybe the other side can illuminate, you know, can
Because
help
you
me,
have
but,
lawyers, and we're bound by what we should know. And we
Well-
should definitively know. And it's, I would say irrespective of that, Judge, the objections were timely filed. I mean, that's the bottom line.
and what about a transcript?
Not timely filed. Again, I'm looking at this as a way to backdoor a transcript and try and kick it back to the
Where's the
court.
ruling on the objections?
I'm sorry?
Where's the ruling on the objections?
There was no ruling on the objections.
Well, that's a problem too, isn't it?
Yes, it is. I mentioned that in the reply brief.
Yeah.
You know, I think I'm here for no good reason. I'd like to have
Well, what's-
my 8 hours that I got in this case at $300 an hour reimbursed by the appellant. I don't belong here. This case doesn't belong here. That's what I mentioned in the reply brief. So here we are. You know, I really would request that sanction. You know, I shouldn't be standing here. I have nothing further. Thank you,
Thank
Judge.
you.
Thank you. We'll be around, you'll have your full 5 minutes for it.
Thank you. Sorry. I don't have a paper copy of the decree handy, but I have included the actual pertinent section in my reply brief, and I'd like to direct the board's attention. It deals with termination, so I think it kind of did come up with a termination date, but termination date is the marriage, and change in circumstances that it substantially makes the existing award no longer reasonable and appropriate. So that's a termination date, but in essence, because there's no other basis for determining how long this should last, it is an indefinite term of support. And Section F, it talks about spousal support is subject to continuing jurisdiction of the court as to duration and amount. Spousal support shall continue until further order of this court. The final judgment entry with the court's independent determination as to the duration of spousal support after testimony and exhibits. That's it. There is no finding of fact. Now, the wife would have you believe that the husband has to request findings of fact, not from a trial court decision. This is the judge's decision.
That's what I'm not understanding.
Yeah, it's,
I'm not understanding that at all, because when I was initially reading it, I was reading it a little bit differently, but I'm just not getting that, so you don't have any disagreement with Mr. Jones in regard to that?
I believe this was not a magistrate's decision.
That's what I'm saying.
It was a decree of divorce, and that it should properly have had findings of fact, findings mandated by the 3105.18. It's not findings of fact, it's a determination of factors. So fact isn't the right word, factors. There's no discussion of the factors that would lead to a lifetime award of spousal support. There's no Rule 53 notice contained here, and even attorneys get to have a Rule 53 notice on their magistrate's decision. That's the Ohio law too. There is nothing that happened in this case that should be allocated to anything except the trial court's complete failure to make any finding that would justify an indefinite term of support for people who are at the age of 50, where both of them are able to earn a really nice living. There are many obligors of spousal support who would like to have earned $63,000 last year. That's the obligee in this case. There is no basis for having someone who just doesn't feel like thinking about continuing her education and maybe earning more in the future.
But alimony isn't just about how sufficient to live, it's about equity in your
It's
income.
not, it's about reasonable and appropriate. You guys,
Reasonable and appropriate, but equity.
this is a court of equity, absolutely, I wouldn't disagree with that. But reasonable and appropriate for someone who earns a substantial living right now, despite her claimed illnesses, which have only caused her to get treatment and had better years of income than she had had before. The record does not support the trial court's indefinite award of support. This court should reverse. Thank you.
And I thank both of you for your presentation. Data again, conflict, I hope your issues taken care of and everything is okay.
Thank you, Judge.
Thank you.
I think, again, the court will take the matter under advisement, will issue a decision in due course. The clerk of court will mail a copy of the decision to you when it is ready, and it will also be available on the High Supreme Court website. Beyond, having said that, our next, we're in